If you're a naturalized U.S. citizen, there's one question that has probably crossed your mind this year, and it's not a small or casual concern. It's a heavy question, one that carries emotion and uncertainty. Can your citizenship actually be taken away? In 2026, immigration enforcement feels more intense than it has in years. It feels louder in the headlines, faster in execution, and more aggressive in tone. Reports talk about files being reopened. Background histories are being digitally cross-checked with systems that did not exist a decade ago. Old applications that once sat untouched in storage boxes are now scanned, indexed, and searchable in seconds. Social media feeds are filled with warnings. Private group chats circulate alarming voice notes about mass citizenship cancellations. Headlines are dramatic, and the anxiety many people feel is real. But here's the problem. Fear spreads faster than facts. Rumors travel further than legal explanations. And when uncertainty fills the air, people often assume the worst before understanding what is actually possible. So before panic fills in the blanks, we need to slow this down and answer the question carefully and correctly. What has actually changed in 2026? What is legally possible under the current law? And who, if anyone, is truly at risk? Because there is a massive difference between political messaging and constitutional reality. Understanding that difference could mean the difference between unnecessary fear and informed confidence. Hi, I'm Sophia, and on this channel I break down complex immigration policy changes into clear, practical explanations so you can understand exactly what applies to you and what does not. Today we're unpacking what is really happening in the 2026 immigration enforcement landscape, especially when it comes to naturalized citizens. I'm going to walk you through what denaturalization actually is, why older citizenship files are being reviewed, who is being scrutinized, what your constitutional rights are, and most importantly, what steps you should be considering right now to protect yourself. This isn't about politics. It's about legal structure, legal process, and documented facts. When enforcement intensity increases, clarity becomes power. And by the end of this explanation, you'll know exactly where you stand and where online rumors go too far. To understand what's happening in 2026, we need to separate two very important things: the law itself versus how aggressively that law is being enforced. Since returning to office in January 2025, President Trump has once again made immigration enforcement a central policy priority. Executive directives have emphasized stricter compliance reviews, expanded fraud detection efforts, and deeper audits of historical immigration records. By early 2026, federal agencies began allocating more personnel, more funding, and more digital resources toward reviewing naturalization histories, particularly in cases where there were potential inconsistencies, undisclosed criminal history, or suspected misrepresentations during the original application process. Now, that increase in attention has understandably created anxiety. When people hear that older files are being reopened, they immediately imagine citizenship being stripped away in large numbers. But here is the key point that must be clearly understood. The law governing citizenship has not fundamentally changed. There is no new statute that suddenly makes citizenship easy to cancel. There is no executive order that allows a government agency to revoke citizenship with a single administrative decision. United States citizenship is protected under the Constitution. It cannot be taken away casually. It cannot be erased through a simple internal review. It cannot be canceled by a surprise letter without due process. This is where nuance becomes critical. There is a long-standing legal process called denaturalization. It is not new. It has existed for decades under federal immigration law. Denaturalization allows the government to seek revocation of citizenship, but only under specific, limited, and legally defined circumstances. Most importantly, it requires a formal civil lawsuit filed in federal court. That means the government must bring its case before a judge. Evidence must be presented in open court. The government carries the burden of proof. The legal standard is clear and convincing evidence, which is not a casual or low threshold. The individual whose citizenship is being challenged has the full right to defend themselves with legal counsel. They can review the evidence, challenge it, cross-examine witnesses, and present their own documentation. There is no secret administrative shortcut. There is no instant cancellation mechanism. Without a federal court case, there is no denaturalization. That structure has not changed in 2026. So what has changed? The intensity of review and the technology used to conduct that review. Federal agencies now rely on advanced digital cross-check systems that were not widely available 20 years ago. Older naturalization applications, some filed 15, 20, or even 30 years ago, are being digitally compared against criminal databases, border entry records, visa applications, asylum filings, tax records, and other federal systems. Paper archives have been scanned and converted into searchable databases. Information that once required manual research can now be flagged within seconds by automated systems. For example, if a variation in a name appears across different documents, the system may flag it for review. If an arrest record existed prior to naturalization but does not appear in the original application, that discrepancy may now be detected more easily than in the past. If travel history conflicts with statements made during the naturalization interview, that inconsistency may be identified through digital comparison. This technological evolution explains why some older cases are resurfacing in 2026. But here is the critical distinction. A digital flag does not equal revoked citizenship. A system alert is not a court judgment. It is simply the beginning of a review process. For the vast majority of naturalized citizens who were truthful, who met all eligibility requirements, and who had no disqualifying factors at the time they applied, increased enforcement intensity does not automatically create danger. Technology may be stronger, reviews may be more detailed, but constitutional protections remain intact. The framework of due process remains intact. The burden of proof still rests entirely on the government. So who is actually being scrutinized right now? Not all naturalized citizens, not entire communities, not individuals from a specific nationality simply because of where they were born. Enforcement efforts are focused on whether citizenship was lawfully obtained at the time it was granted. That distinction changes everything. Denaturalization cases center on fraud, concealment, or material misrepresentation during the immigration or naturalization process itself. They do not focus on what someone did years after becoming a citizen, unless that later behavior reveals prior fraud. One major category under review involves individuals who allegedly failed to disclose serious criminal history that existed before naturalization. The key word is serious. Minor traffic tickets are not the target. Small administrative violations are not the issue. Investigators are looking for undisclosed arrests, convictions, or criminal conduct that legally would have prevented approval if they had been disclosed. If someone concealed a crime that directly affected eligibility, that becomes legally significant. Another category involves identity inconsistencies, cases where different names, dates of birth, or biographical details appear across visa records, asylum applications, green card petitions, or foreign documents. In many situations, inconsistencies are innocent errors, translation issues, or clerical mistakes. But in other cases, they may raise questions about intentional concealment. Intent becomes central in court proceedings. The government must show that any misrepresentation was deliberate and material. Marriage-based green card cases are also being examined in certain situations. If permanent residency was originally obtained through a fraudulent marriage, and that residency later led to citizenship, the legal foundation can be questioned. Again, the issue is not whether someone later built a life, worked hard, or contributed positively to society. The legal issue is whether the original status was lawfully obtained. Here is another critical word in this discussion: material. Not every mistake qualifies as fraud. For denaturalization to succeed, the government must show that the misrepresentation was material. That means it was significant enough that, if the truth had been known, citizenship would not have been granted. A minor typo is not material. A small forgotten detail that did not affect eligibility is not material. The alleged concealment must have directly influenced the outcome. That is a high legal bar. If the government believes fraud occurred, it must file a civil lawsuit in federal court. Once filed, you have rights. You have the right to respond. You have the right to hire an attorney. You have the right to examine and challenge the evidence. You have the right to present your own documentation and witnesses. And importantly, you have the right to appeal if a court rules against you. The process does not end with a single decision. Higher courts can review whether the law was properly applied and whether constitutional protections were respected. If you are ever contacted informally by authorities, you are not required to answer detailed questions without legal counsel present. You may calmly state that you wish to consult an attorney before responding. Exercising that right is not an admission of wrongdoing. It is a constitutional safeguard. Now let's address some of the most common rumors circulating in 2026. There are no verified mass deportations of naturalized citizens. Denaturalization cases represent a very small fraction of the millions of naturalized citizens living in the United States. These are individualized legal actions based on specific allegations tied to a person's file. Speaking your native language does not put you at risk. Traveling back to your country of origin does not automatically trigger review. Maintaining dual citizenship, in most cases, is legally permitted if your other country allows it. Citizenship in the United States does not require cultural abandonment. It is a legal status, not a cultural test. Crimes committed after naturalization generally do not make a citizen deportable. Deportation applies to non-citizens. A citizen cannot be deported unless citizenship is first revoked through the court process. Timing matters. Only concealed pre-naturalization conduct that would have affected eligibility becomes relevant in a denaturalization case. So where does this leave you? Not in panic, but in preparation. If you were honest in your application, met eligibility requirements, and lawfully completed the process, your citizenship remains one of the strongest legal protections under U.S. law. That constitutional foundation remains in place in 2026. Preparation means keeping organized copies of your naturalization certificate, green card records, and original application documents. Maintain secure digital backups and physical copies. If your immigration history involved complexities such as name variations or prior overstays, consider a confidential consultation with an experienced immigration attorney, not because you are automatically at risk, but because clarity provides peace of mind. Immigration policy moves in cycles. Enforcement expands and contracts. Courts review executive actions. Legal challenges reshape policies. Technology evolves. Data systems improve. But constitutional safeguards remain constant. Due process remains central. The burden of proof remains on the government. Millions of naturalized citizens continue to live, work, vote, raise families, build businesses, and contribute to every sector of American society. Enforcement intensity may fluctuate, but lawful citizenship remains one of the strongest legal statuses in the country. Stay informed, stay prepared, and move forward with confidence grounded in facts, not fear.